Thank you. I want to congratulate the contributing authors and the editorial board of the journal and the executive editor, Wei Tan. I particularly want to congratulate David Yang for his work on this issue. And I note that this must be quite an evening for David, being a culmination of so much work over the last 15 months. His dream for this issue has come to fruition. The 4 essays that constitute the thematic part of this issue of the journal are a significant contribution to the academic literature on terrorism and international law. The essays deal with historical aspects of international law and terrorism, the political difficulties of achieving a cross-state united intelligence, military and legal response, as well as political response, to internal and external terrorist threats, the danger that the Special Forces military response, which is shaped to meet the domestic political constraints and battlefield challenges of terrorism, is overstepping the mark in terms of accountability, and finally, whether the extreme measure of extraordinary rendition has so overstepped the mark in terms of accountability, and finally, whether it has so overstepped the mark as to fall within the jurisdiction of the International Criminal Court. Helen Duffy, Professor of International Human Rights Law and International Humanitarian Law at Leiden University, in her book, first published in 2005, The War on Terror and the Framework of International Law, described the search for an accepted definition of terrorism in international law as, quote, resembling the quest for the Holy Grail. Kimberly Trapp, in her essay titled The Potentialities and Limitations of Reactive Lawmaking, a case study in international terrorism suppression, traces the development of international law, in particular treaty law, in relation to terrorism since the time of the League of Nations, as a response to terrorism committed by non-state actors. In this sense, ironically, the agenda of states creating a treaty regime of criminal law enforcement against terrorist acts has been set by those responsible for those criminal acts. Professor Ben Saul, who needs no introduction, in his book, first published in 2006, Defining Terrorism in International Law, noted that, quote, disagreement about terrorism runs much deeper than technical disputes about drafting. It reflected doctrinal, ideological and jurisprudential arguments about who is entitled to exercise violence, against whom and for what purposes. Kimberly Trapp's essay explains how, in spite of these difficulties, reactive treaty making has capitalised on the headline effect that David referred to of terrorist acts to give impetus to overcoming some of these disputes. The second article in the thematic section focuses on a regional state policy response to shared terrorist threats, namely Southeast Asia, a region of particular interest to Australia in terms of terrorism since the Bali bombings of 2002. Authors Sang Tan and Hitoshi Nasu note that compared to other regions of the world in recent decades, ASEAN states have been slow to adopt a treaty on counter-terrorism. They examine the various reasons for this lacklustre pace, including a culture of non-interference between member states, a suspicion that neighbouring states harbour sources of militancy and terrorists, and domestic political resistance in the interests of national harmony. The essay provides a valuable understanding of how the complex political interrelationships of the states of our neighbouring region have made consensus on this issue difficult to achieve, but notes that since the ASEAN Convention on Counter-Terrorism, which finally came into force in 2013, the member states have benefited in building their legal and operational counter-terrorist capacity. The third essay, by John Moran, Time to Move Out of the Shadows, considers the role of special operations forces in counter-terrorism and counter-insurgency operations. Mr. Moran acknowledges their positive role in response to recent terrorist activities and armed conflicts, but also examines the negative aspects of their operations, principally their secretiveness and the way in which they stand outside usual channels of accountability. One of their positive roles that he notes has been detaining war crime suspects in the Balkan conflict in the early 1990s. Indeed, many of those who found their way to The Hague, including a trial that I appeared in, were captured this way. Finally, Fiona Lau, in the fourth essay, examines the legality of American treatment of high-value detainees in the so-called War on Terror, particularly through its extraordinary rendition program, and poses the question whether prosecutions for crimes against humanity by the International Criminal Court are possible and, if so, plausible. I want to share with you some thoughts on a few aspects of the challenge that terrorism poses for criminal law. An issue of the UNSW Law Journal with a thematic component on terrorism and international law has a particular appeal for me, both as a municipal criminal lawyer and an occasional international criminal lawyer. Often there are significant challenges for the defence in representing accused persons who are charged with terrorism offences, so as to ensure a fair trial. The often random nature of terrorist attacks against the community means the jurors, being drawn from the community at large, can identify as being part of the alleged target group, and therefore can be predisposed against persons charged with such offences. This prejudice can be compounded by special measures being taken at trial where the authorities perceive a continuing threat. Such trials tend to be complex, lengthy and expensive, given the circumstantial nature of the evidence. Some of the evidence may be confronting to the jury, where it involves still images and video of violent and sometimes horrific acts. In the Elamar trial in 2008 and 2009, arising from the AFP operation known as Operation Pandanus, there were 5 accused. For the duration of the trial, which took 11 months, they were in a dock behind specially strengthened glass. 2 of the 5 accused were represented by public defenders who dealt with those issues as best they could, but there is no perfect solution. The cornerstone of criminal law, both municipal and international, is individual criminal responsibility. The crime of terror in international humanitarian law often involves state actors and, in that circumstance, career military personnel and politicians for whom the prospect of trial and punishment in a municipal or international criminal court has a deterrent effect. To illustrate that, when I worked at The Hague in the Office of the Prosecutor for the UN International Criminal Tribunal for the former Yugoslavia, we used to have morning meetings where all the agency heads would come together. We'd call them prayer meetings. At one particular meeting, as we listened to the summary of what had happened relevantly, according to the media, in the previous 24 hours, we heard that a minister in the Macedonian government had expressed concern to his Prime Minister that by following the Prime Minister's orders to quell a public protest involving the Albanian minority population of Macedonia, he ran a risk of attracting the jurisdiction of the ICTY. Well then, responded the Prime Minister, you'd better make sure you act legally so that you don't. We were well pleased to hear that story. Query, however, whether a fanatical terrorist, however motivated, is as deterred or deterred at all by arrest, trial and the prospect of punishment. The failed suicide bomber, be they a Sri Lankan Tamil tiger in the height of that armed conflict, or a lone wolf operating in a suicide mission in Western Europe, may have little fear of imprisonment and indeed embrace the opportunity to go on trial and spread the message. This potential impotence of criminal law is a conundrum challenging the rule of law itself. You may recall a few years ago gruesome images published by ISIL of an Australian-born terrorist, Khaled Sharif, in Syria, holding up the head of what he claimed to be an executed Syrian prisoner. Worse still, images of one of his young children doing likewise at his behest. Sharif had previously been imprisoned in New South Wales for a terrorist-related offence. He was one of those charged as part of Operation Pandanus and pleaded guilty to a charge involving possession of 6 clocks, 140 batteries, and a video containing instructions as to how to construct and detonate an explosive device. His sentence had been mitigated by evidence that he had suffered from schizophrenia at the time of his offence, in circumstances which had lessened his criminal culpability and made him an inappropriate vehicle for general and specific deterrence. And I might add, there was nothing improper at all about the sentence, and it was not appealed by either the prosecution or defence. At the time those images were published, Sharif claimed in a public statement that he had feigned the mental illness to fool the courts into giving him a reduced prison sentence. Since then, he is thought to have been killed in an airstrike. Sharif's claim that he feigned mental illness may well have been a delusion itself. In other words, he may still have been suffering from schizophrenia. An experienced forensic psychiatrist had given evidence at his sentence of his illness, which was well documented over years beforehand. The psychiatrist maintained his opinion following Sharif's later claim. Nevertheless, clearly the punishment handed down by our criminal justice system had done nothing to deter Sharif. Fanatical terrorism is a formidable challenge to the criminal justice system in other ways. Sharif had spent most of his time in prison in the secluded, what's known as the High Risk Management Unit at Goulburn and Lithgow prisons, despite recommendations that he be transferred to a secure psychiatric unit. The same psychiatrist whose evidence was used on sentence claimed that the outcome may have been different had Sharif been treated for his mental illness in prison. This touches on another dilemma. Allowing such prisoners to mix in the prison population may facilitate the spread of a terrorist culture, but on the other hand, isolating them may concentrate their antisocial terrorist mindset. These are difficult choices. Corrective Services now has a course designed for prisoners who are committed to politically or religiously motivated violence, known as PRISM, P-R-I-S-M. So it will be interesting to see how that unfolds in terms of its impact on prisoners who have terrorist ideologies. One of the challenges in international criminal law has been to isolate the criminal culpability of terrorising a civilian population, particularly as a war crime. As David has mentioned, a senior trial attorney for the Office of the Prosecutor in ICTY, I led the prosecution case in a trial involving the infliction of terror on the civilian population as a war crime, the Galich trial. Since World War I, bombing campaigns on civilian populations as a means of leveraging military victories through the infliction of terror has been condemned. However, little happened to fashion that concern into a discrete war crime, as opposed to an adjunctive descriptor of behaviour consequential to other existing crimes, such as the deliberate or reckless targeting of civilians. The massive bombing campaigns of civilian populations by both sides in the European theatre of World War II, such as the German bombing of British cities and the Allied bombing of Hamburg and other German cities, led ultimately to the issue being addressed in the 1977 additional protocols to the 1949 Geneva Conventions. Article 51.2 of Additional Protocol 1 and Article 13 of Additional Protocol 2 are in identical terms. The civilian population as such, as well as individual civilians, shall not be the object of attack. Acts or threats of violence, the primary purpose of which is to spread terror among the civilian population, are prohibited. The first time these provisions were invoked as the basis of a war crime was in the Galich trial in the ICTY. The context was the 3-year siege of Sarajevo, the capital of Bosnia and Herzegovina. For 2 of those years, Galich was the commander of the 18,000 Bosnian Serb troops that encircled the city. He was unable to deal a final military blow to clinch victory because although he had the advantage in firepower, some 1,000 pieces of heavy artillery, tanks, rocket launchers and the like, he was heavily outnumbered by the 90,000 soldiers defending the city. And so what transpired was a stalemate, very much like a World War I battlefield, with trench lines so close that they could throw bombs at each other. So instead of seeking a battlefield victory, pursuant to orders from his military superiors, he sought to undermine public morale by deliberately targeting civilians by small arms, mortars, rockets and his heavy artillery. The consequence was that for 3 years the 400,000 civilians trapped in the city lived in a permanent state of terror, regardless of whether they were in their apartments or on the streets. They lived with the terror of knowing that they and their loved ones could be killed at any moment. At the outset of the conflict, the parties had agreed to be bound by the Geneva Conventions. So the issue for determination was confined to treaty law. There was no need for the court to determine whether the crime existed as such in customary international law. A challenge for me and the prosecution team as a whole was to convey to the court the enormity of this alleged crime by Galich. We set out to prove that he was responsible for over 1,000 civilian deaths and over 10,000 civilian serious injuries that could be attributed to his campaign of sniping and shelling civilians, not only as part of the evidence base for the terror count, but also as the basis for 2 separate counts of crimes against humanity, the foundational crimes being murder and serious injury. We were concerned that there would be a temptation for the court to give primary consideration to the crimes against humanity counts and discount the terror allegation as somehow less serious. We set out to convey to the court, through the evidence of surviving victims, eyewitness accounts from journalists and peacekeepers, and video, just what the experience of living in constant terror for a period of years was like. And we also included expert evidence from a British psychiatrist who specialised in torture of refugees. We wanted to make the point that as serious as 1,000 murders is, and 10,000 seriously injured victims, terrorising a civilian population of a city is uniquely serious. This was a continuing crime in which Galich's mens rea was refreshed on a daily basis. The court had to determine first whether such a crime as a crime of terror existed. It said this: "The majority is of the view that an offence constituted of acts of violence willfully directed against the civilian population or individual civilians causing death or serious injury to body or health within the civilian population, with the primary purpose of spreading terror among the civilian population, namely the crime of terror as a violation of the laws or customs of war, formed part of the law to which the accused and his subordinates were subject to during the indictment period. The accused knew or should have known that this was so. Terror as a crime within international humanitarian law was made effective in this case by treaty law. Whether the crime of terror also has a foundation in customary law is not a question which the majority is required to answer." Galich was convicted of this offence and the 2 counts of crimes against humanity for murder and inhumane acts, and received a sentence of life imprisonment. It's one of the very few sentences of life imprisonment that have been handed down by the ICTY, and his was the first. Galich was the first person to be convicted of the war crime of terror but he was neither the first nor the last military commander to order his subordinates to commit such acts. In the last few years, the Syrian government is alleged to have used chlorine on civilian populations in rebel-controlled areas. In the last few days, there have been reports of bunker-busting bombs being dropped in civilian areas of Aleppo, causing massive civilian casualties and terrorising the civilian population. There is much work still to be done. In the meantime, I commend the authors of these valuable essays and the editor and editorial board for ensuring such a high-quality contribution to the store of knowledge and discourse on terrorism in international law. Thank you.